I have had Green Bay city aldermen relate to me issues of ordinance violations which the city could not or would not address because of its service agreement with the Oneida Tribe. And some of these complainants have been enrolled Oneida tribal members themselves as well. So this is a problem that it doesn't matter whether you're tribal or non-tribal. It's a problem. So let me explain a little bit about service agreements. The Oneida Tribe, and it isn't just the Oneida Tribe, when an American Indian tribe has land that is held in trust on their behalf by the federal government, it's not taxed. In a way, everyone here, I assume, is somewhat familiar with annexation. When a city annexes property from a neighboring municipality. You know, there may be a kerfuffle and some discussion and debate, but at the end of the day, if the annexation is successful, what happens is the gaining community gains the new tax base, but it also incurs the responsibility to provide services. The losing municipality loses tax base, but it also loses that responsibility. So on paper, it theoretically works out to a net zero change. With respect to having land put in a trust, a community like Hobart will lose tax base. In that regard, it is like an annexation. However, we still have the responsibility to serve, to snowplow, to build roads, to provide public safety, to plan, and on and on. So it is actually a double win. The intention of service agreements is to blunt that, to offset that. So it is a vehicle by which a tribe can agree to reimburse that host municipality for services provided, payment in lieu of taxes, if you will. And they call it a pilot agreement in the world of government. So that's essentially what a service agreement is intended to do. With respect to Hobart specifically, we had a service agreement. It was signed, executed in late 2004. It had a term of 3 years. It obligated the Oneida Tribe to pay an annual payment to the village of Hobart in exchange for services provided. That dollar amount, though, was calculated as prescribed by the agreement. The Oneida Tribe was credited with services that it provided. The village was credited with services it provided. Typically, the latter was more than the former, so it would have been the tribe that owed the difference. And it was also defined in there as to how that would be calculated based on assessed property values and so forth. Along the lines, in one of the annual payments, it was inexplicably delinquent, but then it also became problematic for the village of Hobart in that that service agreement also required the village of Hobart, obligated us, precluded us from opposing any applications of land going into federal trust. Normally you would, if there was good reason, you would oppose it. We would have to forsake that right. That was a condition of the service agreement. So after almost 3 years, we and the tribe negotiated for a short term, or for a short while, to renew it. And we decided, or it was our thinking at that point, that any service agreement between the Oneida Tribe and the village of Hobart, I'll simplify it, but any agreement in our view should assume nothing more but an invoice. Here's what you do, here's what we do, here are the two costs, here's the net difference, here's the money owed to whom. We in the village side of the table had a problem with also being precluded precluded from opposing any land going in a federal trust. And the tribe, from their side of the table, did not agree with our position. So that essentially was the end. That 3-year service agreement died a natural death. It was not renewed, and the village of Hobart has not had one with the tribe since. The loss of property tax money is obviously an important factor. But at least in my view, a more important factor is the loss of coherent municipal planning and jurisdictional responsibility. Now, that allows me to discuss a little bit here about the Green Bay agreement with the tribe. Over 2 years ago, 3 years ago, the city essentially asked for our help with them. They were, as they were entitled to, renegotiating. They had one of those window of opportunity that their service agreement allowed. They were renegotiating with the tribe. And they were contemplating these similar terms. The inability to challenge land going in a trust. The unilateral willingness to essentially walk away from jurisdictional authority on land owned by the tribe or by tribal members in fee, not even in trust. There were a number of issues between the city and the tribe, and the city asked the village of Hobart basically, what is life like without a service agreement? They wanted to know. So I appeared before the city council and I explained our rationale, our municipal authority, and our newly found degrees of freedom without money as leverage. There are some things that we felt are too precious to be purchased. Eventually, the city itself terminated their service agreement in April of 2016. So that's the status of the city with respect to service agreements. There is a service agreement in place at this time. It is between Brown County and the United Tribe. It's my understanding that it is currently being revisited by the county, as is their right under the agreement. And the village of Hobart has been advised by its 2 county board supervisors, Rich Shadowall and Dave Landwehr, that this is the case. The county assumes their annual service agreement payment in their budget proposals. And in exchange, they agree to relinquish ability to oppose land going in a trust and some jurisdictional authority that they would otherwise have, but in my opinion, have no right to sell. Like the village and the city, our position would be that the service agreement should either be terminated or at least propose a straightforward invoicing without conditions that should stand on their own legs as matters for resolution in other standalone agreements, as opposed to everything being conditioned on pilots, or getting pilot payments being conditioned upon other conditions being satisfied. So that's the status. It's a short definition of service agreements, and that's the status of what had been and what still is service agreements in the area here with the United Tribe. The next item on the agenda here brings us our next presenter, who is by no means a stranger to Hobart, nor to many of you, Elaine Willman. Elaine is at the head table here. She is herself part Cherokee, mixed with other ethnicities. She's an extremely articulate and fearless spokesperson for the equal rights of everyone, tribal and non-tribal alike. Elaine is the author of 2 books, Going to Pieces, the Dismantlement of the USA, and the second book entitled Slumbering Thunder. Both are found on Amazon, as well as being the author of countless articles regarding federal Indian policy. Elaine worked for the Village of Hobart as its tribal affairs consultant. In addition to interim posts as village administrator and community development director and coffee maker and so forth, on-site here in Hobart from 2008 to 2015, Elaine is still our tribal affairs consultant, but has been living and working in western Montana. She is frequently sought after for speaking events, interviews, and writing assignments, just as she has been, in order to come here and join us this evening. So with that, I will get out of your way, Elaine.
It's going to be hard to talk with a lump in my throat because I have some of the deepest, most rich personal and professional memories here. The 8 years that I worked for the Village of Hobart required everything I ever learned working with other local governments in California and Washington State. It required everything I ever learned about anything, and then a lot of things I had to learn on the job here. And it was the most fulfilling, sometimes frustrating, fulfilling, productive, professional experience I've ever had. And it grew me some more. You know, we always grow one job to another or one thing, but it grew me some more. And I had a deep sense of dedication to this village. They brought me in, we said that I'm Cherokee, and that reminded me of something. There's quite a few YouTube videos and talks that I give, and in writing and on film. I have said that I am French and Cherokee because that's what my folks told me all my life, and I've had this innate affection for American Indian history and all things Native American. I've had that lifelong, and I still do. And my husband is Shoshone, and a descendant of Sacagawea. But it occurred to me with Elizabeth Warren being called Pocahontas, and being challenged to do a DNA test, it occurred to me, you know, for years I've been telling everybody I'm French and Indian, but am I? Am I? So in December, I did one of those DNA tests. And lo and behold, I don't have a lick of French. Zero French. But I'm 30% Native American from the southeastern United States. That's the Cherokee. And so now I've got to document it. I'm a lot more comfortable. And I hope Elizabeth Warren gets her DNA done soon, too. I just want to say that I have always worked with little governments, little towns, small bills. In the city of Ojai, California for 10 years. Toppenish, Washington on the Yakima Reservation. I've never been remotely interested in working for a county government or the state level. I like that interaction with the president, I don't care who he is, from Washington to a local elected board meeting, council meeting, and just say, I think this, I want this. That interaction, that we the people, right down to the ground level of local governments.